My name is Sheila Heymans. I'm the Executive Director of the European Marine Board, and I want to welcome you to the European Marine Board's third Thursday Science Webinar Series. I think there will still be people arriving, but I will go through the introductory slides now already, and then we can start when there's more people with the important talks. So going forward, I will talk about some housekeeping rules. Please make sure that your name is clearly entered so that when you ask a question, we know who you are. Also, please use the Q&A to ask your questions. It should be at the bottom of your screen. And if you put a question in there, also it would be helpful if you give us the organization, the name of your organization and the country that you are from. And once the speaker has finished talking, then I will moderate the discussion and look at what questions are there. If you have any technical issues, you could use the chat function. Angel is there, and I think he's got technical support next to his name in chat. Please be aware this webinar is being recorded and it will be available on our website and on our YouTube channel. So without further ado, let's go to the important things. This webinar is entitled The Risk and Long-Term Liabilities of Subsea Carbon Sequestration. It is linked to our very newest Future Science brief that came out last year, end of last year, on the monitoring, reporting and verification of marine carbon dioxide removal. And you can download it from the website. You can see the link at the bottom there. Our speaker today is Gabriela Argüello. She is a associate senior lecturer in environmental law at the University of Gothenburg, also a research fellow of the Royal Swedish Academy of Letters, History and Antiquities, and she was a member of the working group on marine carbon dioxide removal. So without further ado, I see that you're there. Very good. I will stop sharing, Gabriela, and you can go ahead.
Thank you, Sheila. I will now share with all of you my screen instead. So I hope you all can see the presentation now.
Yes, and it's in presentation mode. So there we go.
So thank you very much to the European Marine Board for this invitation. As you mentioned, Sheila, I had the great pleasure to contribute to the science brief from MRB for marine carbon dioxide removal. Today, instead, I will discuss carbon capture and storage, or CCS for short. In particularly, I will talk about long-term liability of storage of carbon streams under the subseabed. This project is financed by Marianne and Marcus Wallenberg Foundation, and I'm participating in this project with colleagues from Lund University as well. So by liability, I refer to the risk allocation over decades. The risk allocation and the responsibility to remedy or compensate for damage can be shared between several operators, between one operator and the state, or be just subject to one operator. In the following slides, I will show you all how the different stages of CCS and the multiple actors involved in this process. But first, I would like to start with some basic background. So what is CCS? The Intergovernmental Panel on Climate Change, the IPCC, defines CCS as a technology that involves capturing CO2 before it can be emitted to the atmosphere. Then you have to transport it to a secure location and isolate it from the atmosphere, for example, by storing it in a geological formation. So we all know that the G20, and this is the world's major developed economies, including the EU, are responsible for almost 80% of global greenhouse gases emissions. For this reason, their mitigation policies are decisive to meet the climate change challenge. In the sixth assessment report of the IPCC, It urges that the state reduce fossil fuel use, so this is the most important, and to use CCS in all remaining fossil fuel systems to reduce CO2 emissions in the future. At EU level, the Industrial Carbon Management Communication adopted by the European Commission in February of 2024 provides details of how CCS, according to the EU, will contribute to reducing emissions by 90% by 2040 and finally reaching climate neutrality by 2050. But despite the increasing support of this technology, especially in the European Union, a business case for this has not been fully reached yet due to financial constraints, unfavorable market conditions, and many regulatory hurdles. Furthermore, the International Energy Agency and the European Commission have identified a potential bottleneck to scaling CCS, and this is the shortage of available storage sites on land. So that is why one of the major reasons why states are looking at the sea. And the North Sea continental shelf is a promising available storage site for CO2. However, there are many critical voices concerning whether we should actually consider CCS as a mitigation technology. From a socioeconomic perspective, one could argue that CCS will slow the phase out of fossil fuels. From a legal perspective, mitigation has two main objectives. The first one is limiting anthropogenic emissions. And we can say that CCS will do that because they prevent emissions that otherwise will go into the atmosphere. The other main objective of mitigation is to enhance sinks of greenhouse gases. And the ocean is the most important natural sink for greenhouse gases. We should then analyze what risks CCS pose to the marine environment and what will be the impact of the ability of this sink to continue to absorb CO2 in the future. So in this graphic, you can see that CCS encompasses a series of stages. First, the capture of CO2, the transportation, and this transportation can be transboundary. Then is the injection phase, the site closure, and the long-term monitoring of these sites that are closed. From the graphic that you see in your screens, you see that there are many operators, including emitting industries, carriers. Carriers could be trucks, could be ships. Most of them today are transported also by pipelines. And there are also the CCS operators and, of course, states. At present, there is no comprehensive legal framework that governs all of these stages. They are regulated by different type of legislation. It could be climate change law, industrial activities, property, transportation, port operations, waste management, dumping, health, and environment. So before we go how risks are translated into a legal scenario, the risk that posed for the marine environment relate to to carbon leak, basically. And what is a carbon leak? Is the migration of these stored carbon streams out of the permitted geological storage complex in a way that it could reach the seabed or the water column, it enters other geological formations, or compromises the integrity of the storage site. So in this last case, the loss of containment itself is a risk even before environmental damage occurs. If carbon streams reaches the water column, it could intensify acidification of the seawater, but according to the literature available, the effects will be mainly localized, but it will affect calcifying organisms, venting ecosystems, larvae stages of fish. So even if localized, this will trigger liability from a legal perspective. Then leakages could also cause ecological toxicity and habitat disturbance. because elevated CO2 concentrations can impair respiration in benthic fauna, disturb microbial communities, and damage protected habitats. Other potential damage are gas bubble plums that could disturb sediments and benthic organisms. So even in cases of small but persistent leakages, that undermines a particular presumption of CCS, that is permanence, the permanent storage of carbon. For example, under the EU emission trading system, leaked CO2 must be reaccounted as emissions. Subseabed leakages are especially legally sensitive because C2 plums or acidified water do not respect any type of boundaries and could cause transboundary harm, including the migration of CO2 to neighboring continental shelves or affecting neighboring exclusive economic zones and, for instance, damage shared fish stocks. However, according to the literature, CCS is widely considered technically feasible and safe. This, of course, doesn't mean that it's risk-free, which is why long-term monitoring and liability frameworks exist under the law. From a legal perspective, liability are not just based on probability, but also on irreversibility and time horizon. Based on this, the European Union has been the only organization on regulating liabilities in terms of monitoring obligations, financial securities, and the assurance that the liability will be transferred to the state after a strong evidence of the permanent storage of carbon. So the next question is, well, in the light of this risk, what does it mean from a legal perspective? So liability from CCS at sea can cover a wide range of aspects. For example, an operator will be held liable if it is not complying with national or regulatory obligations concerning monitoring or reporting to the authorities. We can also talk in loose terms about climate liability, since emissions must be accounted if there are leaks. Environmental damage liability can also occur with obligations to restore habitats or to compensate for damage. Civil liability will also occur in the case of torts, contracts, and third-party damage. Finally, in the case of transboundary harm, we enter in the realm of state responsibility. Based on these liabilities, we should also consider what legal frames are potentially applicable to CCS at sea and how they relate to the liability questions. I am going to go through international law, regional regimes such as OSPAR that governs the Northeast Atlantic, HELCOM that governs the Baltic, and the European Union. So if we start with the 1982 United Nations Convention on the Law of the Sea, that I will call UNCLOS, is the primarily legal instrument that governs directly or indirectly any type of activities taking place at sea. Although UNCLOS does not refer to carbon storage, the treaty established preconditions for the exercise of jurisdiction at sea and imposes a series of obligations on all states to protect the marine environment from any type of pollution that come from diverse sources. In this case, CCS has been regulated as dumping, so the deliberate disposal of wastes at sea. States that do not comply with these main obligations, that do not regulate these activities taking place at sea, will be held liable under international law. So let's move on to the regime that regulates at the moment CCS in international law. And the dumping regime is fundamental to assess liability because it is the main legal framework where we are going to assess permissibility of subseabed storage. In a nutshell, dumping is a source of marine pollution that involves deliberately disposing of land waste at sea. Dumping is regulated by two main treaties, the London Convention, which has a permissive approach, and the London Protocol, which is much more stricter and that eventually will replace the convention. But this hasn't happened yet. The parties to both conventions have discussed for many years the potential regulation of carbon streams as waste subject to these conventions. Parties to the London Convention, so the older legislation, must prohibit the dumping of all substances listed in Annex 1. This is known as the black substance list. They need a special dumping permit if waste are listed in Annex 2. And if they are not listed in Annex 1 or 2, it's just a general permit which is required. Carbon streams or CO2 is not listed in Annex 1 or 2. So in principle, states that are only parties to the London Convention could argue that carbon streams can be sequestered without any legal impediment under their jurisdiction, and they will follow the general obligations to protect the marine environment. However, Annex 1 includes industrial waste, defined as substances generated by manufacturing or processing operations. This could, of course, encompass carbon streams captured in industrial activities. If this is the case, CO2 under the London Convention is prohibited and cannot be sequestered without incurring into consequent liabilities. The London Protocol, on the other hand, is the only international instrument that explicitly regulates CCS and also the related export of it. Under this instrument, all dumping is prohibited unless exceptions provided in Annex 1. In 2006, the convention was amended to allow subseabed carbon sequestration. This means that the storage in water column is still prohibited. The amendment was at the time adopted despite knowledge gaps concerning expected composition of carbon dioxide injection streams and uncertainties regarding the stream's behavior and interactions with other substances. The London Protocol also establishes a general provision concerning waste exportation. What does it mean? It means that if you want to sequester CO2, you will have to do it in your own territory, including your own maritime zones where you exercise jurisdiction. But in 2009, an amendment allowing the exportation of carbon streams for sequestration was adopted. But this amendment is not in force. So given the slow pace at which the amendment is set to enter into force, the parties adopted a resolution in 2019 to provisionally apply it. And this is allowed under international law. For this, states shall enter in bilateral agreements and consent to be bound by the 2009 amendment. What is worrisome and could be subject to further liabilities in the future is that the resolution also covers entering into agreements with non-contracting parties. Also, one should investigate further up to what extent, in which period of time can states make use of a provisionally application of an amendment that is not entering into force. So what means provisional application? What is the timeline that we should consider? So as an interim conclusion, the amendment and resolution under the London Protocol allows carbon streams to be exported based on an agreement. But according to the European Commission, the directive on geological storage on carbon dioxide and the directive establishing a system for greenhouse gases emissions allowance trading within the EU are the same and act as relevant arrangements in the meaning of Article 6.2. This means that agreements will only be necessary in issues that are not covered by European law. This interpretation, I consider that is an attempt to circumvent the obligations established under the London Protocol and could potentially give rise to liability. It is noteworthy that despite the interpretation of the Commission, Belgium and Denmark, for instance, entered into a bilateral agreement as required by the 2019 resolution. So, if we move to the North Sea area where most of the CCS is planned to happen in Europe, we have the main legal framework is OSPAR. This is a regional sea convention covering the Northeast Atlantic and most of the North Sea. In 2007, the convention was amended to permit carbon storage only in geological formations beneath the seabed and make such storage conditional to strict permitting requirements that include site characterization, monitoring, corrective measures, reporting, and review. Although OSPAR does not regulate CCS as comprehensively as the EU CCS directive, it clearly endorses a life cycle logic in the pre-injection, the operation, and post-closure management, such as the assurance of containment, continuous observation, and monitoring of the site. To support the parties, OSPAR adopted in 2007 guidelines introducing a framework for risk assessment and management, requiring iterative risk management based on monitoring, if necessary, reassessment, and adjustment. Although OSPAR do not explicitly allocate any type of civil liability and does not create a formal transfer of responsibility between operators, it still shapes long-term liability by defining what counts as an acceptable risk, requiring continuing monitoring and reporting, and embedding a duty of prevention and remediation that is clearly consistent with UNCLOS obligations and EU environmental liability concepts. But while OSPAR has created a relatively clear pathway for CCS to happen in the North Sea, the Baltic Sea context under HELCOM raises more fundamental questions about how CCS fit within this regional protection law. So the Baltic Sea presents a different environmental and legal context from the North Sea, which has significant implications for CCS. The Baltic Sea is a semi-enclosed marine area with limited water exchange, making it particularly vulnerable to pollution and ecological disturbance. It is already subject to severe environmental pressures, including eutrophication, hypoxia, and biodiversity loss. These physical characteristics are reflected in a dense regulatory framework under the Helsinki Convention, which is explicitly oriented towards marine protection rather than resource use. A central legal issue under the Helsinki Convention is the classification of CCS activities and storage. A fundamental interpretative question is whether the injection of CO2 constitutes dumping under this convention. If it is, CCS is prohibited. Even if we interpret it more narrowly, one can say, well, if CO2 is not a dangerous substance, this is nothing more than a permitted use of the seabed. CCS will still need to be justified under environmental protection standards. So there is now in the Baltic Sea a lack of a clear legal categorizations, meaning that if this uncertainty persists, it is in itself a risk and an investment risk as well. Transboundary sensitivity further amplifies this concern. The Baltic Sea is characterized by close geographical proximity between the states and ecological interdependence. A leak occurring within one exclusive economic zone could readily affect other shared waters and shared fish stocks. Consequently, CCS in the Baltic Sea implied heightened obligations of notification, consultation, and cooperation under international law. States authorizing CCS in the Baltic Sea retain heightened international responsibility even after a storage site has technically been closed. And then we enter to the European legislation. And the EU, as I mentioned to you before, is the only region with a comprehensive regulation on CCS. The CCS directive regulates the entire life cycle of a storage site and explicitly integrates long-term liability management. The directive adopts a life cycle approach, as does OSPAR, that extends from site selection and characterization through operation and closure and into the post-closure phase. Permits must include conditions on monitoring, reporting, the establishment of corrective measures, and several financial securities, all of which are designed to ensure that the operator remains responsible during the operational phase. So, but the most distinctive feature of the CCS directive is the mechanisms from the transfer of responsibility after a site is closed. This transfer represents a deliberated policy in the EU, by the EU legislator to address a temporal issue. This is a temporal mismatch between private investment and the multi-decadal or multi-centennial timescales of which geological storage must remain secure. By introducing a transfer of responsibility from the operator to the state, the CCS directive creates a hybrid liability model. During the operational phase and initial closure of the site, the operators bear the main responsibility based on the polluter pays principle. Over time, however, it is the state that assumes the stewardship of the closed site. So in this sense, the CCS directive does not eliminate long-term liability, but rather reallocates it. It transformed the question of whether there should exist something that we can talk about long-term liability over many decades to the question who should bear that type of responsibility for such long periods of time. In the case of the EU, the answer is the state should bear these risks. So, but what exactly is transferred to the authorities? First is that the competent authority will assume the responsibility for monitoring and corrective measures under the CCS directive. These include observing the behavior of the stored carbon streams, detecting irregularities, and assessing whether the storage site continues to perform as predicted. If monitoring reveals anomalies or evidence of leakage, it is the obligation of the reporting authority for taking corrective measures as well. Second, the transfer of responsibilities have also direct consequences for the EU emissions trading system. During the operational and pre-transfer phases, any leakage of CO2 from the storage site is treated as emissions attributable to the operator, who must surrender allowances according to the law. After the transfer of responsibility, this obligation ceases to apply to the former operator. But it is important to think that the legal system is not closed. It is always interacting with other legislation. That is why we call the law as a system. So the European Environmental Liability Directive is particularly relevant during the operational phase prior to the transfer of responsibility under the CCS directive. If leakage or irregularities from a storage site cause damage the operator may be required under the Liability Directive to take preventive action, to carry out remediation, independently of the conditions of the CCS permit, even after the transfer of responsibility to the competent authority. This directive will continue to be relevant. While the CCS directive relocates forward-looking responsibility, national implementation of the Environmental Liability Directive and related civil liability regimes may still apply to damage linked prior to the conduct or to the failures that occurs before the transfer. So before I finish this talk, I would like to say that the governance of long-term liability for subseabed carbon and storage does not rest on a single legal instrument, but on a layered system of protections that address different dimensions of risk. The first line of defense is provided by international law, in particularly UNCLOS and the London Protocol. Together, these instruments establish the basic permissibility of subseabed carbon sequestration while imposing minimum safeguards for the protection of the marine environment. In the light of UNCLOS, we can understand CCS alongside the general duties to preserve the marine environment and to prevent significant transboundary harm, anchoring long-term liability to the state, at the state level. The London Protocol, in turn, enables subseabed geological storage of carbon streams under controlled conditions, ensuring that CCS is treated as a regulated activity and not as an activity free. Is not an exception from general marine pollution rules. The second line of defense operates at regional levels. In this case, I have briefly talked about OSPAR and HELCOM because these regional treaties translate general obligations to a context-specific case. Where OSPAR has established a relatively clear pathway for CCS to happen in the North Sea, HELCOM illustrates how regional marine protection law can render CCS legally uncertain, subject to heightened scrutiny, and maybe to potential prohibition. The third and most operational line of defense is the example of the European Union, particularly because of the CCS directive. This framework translates international and regional principles into concrete liability regimes and this life cycle approach towards the storage site. Through these requirements of monitoring, corrective measures, financial securities, and post-closure financial contributions, the directive seeks to ensure that liabilities are both clearly allocated but also funded. It is, as I mentioned to you before, the most distinctive feature of this directive is the transfer of responsibility mechanisms, which allows responsibility to move from the operator to the competent authority once permanent containment has been demonstrated, or at least there is strong evidence about it. So thank you very much for your attention.
Thank you very much, Gabriela. That was very, very interesting. I see we have some questions in Q&A, and I have a few of my own, but please remember for the rest of the audience, if you have more questions, use the Q&A. Okay, I think the first question came from Tracy O'Shea. She said, is there a risk that the carbon storage leaks or is released in mass? So instead of just bubbling out slowly, if it releases in mass, even storage at sea, I imagine, could affect the marine environment. I think that's a very technical engineering question. The question is, you know, instead of it slowly bubbling out, do you think it could just all escape at once?
Well, yes, this is a technical question. In principle, according to the literature, this is very unlikely, but this is what we call these catastrophic risks, that
Mm-hmm.
even though they are very unlikely, you should have legal guards for it. But
Mm-hmm.
this type of catastrophic risks, if those happening could have severe consequences for the marine environment, then it's a discussion, should or not CCS happen?
Yes. Yeah.
That is, I think, the main regulatory question that opens once this, if there is a massive release of CO2.
Yeah. Yeah. And then we have an anonymous attendee who asked, is there any risk related to carbon storage adjacent to nuclear waste in subsea areas?
Well, there is, again, I think this is very technical, but when you select the site and the characterization, of course, there is there should be an analysis of if there is any possibility of migration of the streams, and
Mm-hmm.
if so, how they will interact with other substances. So at
Mm-hmm.
least this is considered, but of course, this is subject to risk analysis and environmental impact assessments.
Yeah, and I guess following on from that, a question that I have, um, if um, if there's a decision to do CCS, I guess there's some sort of geological analysis that takes place, a whole situational analysis of how big the area will be. And then I guess they would look at all the other things, there's, subsea or munitions that are dumped at sea and all sorts of things that actually could probably have an impact. So I guess when these kind of decisions are made, they do an impact assessment to look at what the extent of all of that would be, right?
Exactly.
Yeah.
So based on this, is the license is given, and well, the operators will start. And if there is an imminent probability of damage, well, the operation must stop
Yeah.
based on the precautionary approach and prevention of environmental
Yeah.
damage.
Yeah. Then maybe the same, or maybe another anonymous attendee asked, is there any agreement between non-EU EU states? So I guess between the EU and non-EU states, or say between the UK and Norway, for instance.
Well, Norway,
Yeah.
if I am,
So
but with Norway, there are several agreements, because this is the state with most experience in storing carbon. But I guess the question is if there is agreements beyond Europe
yeah.
with European
Yeah. Yeah.
countries. I am not aware that those exist yet, because there is still in pilot mode. There is the
Yeah.
Northern Lights project happening in Norway. So if they are successful, and if there is the possibility to find alternative storing sites elsewhere in the world, then it's something that we should look closer. Also because of a matter of environmental justice or equity, because we should consider that now there is a strong support for transporting carbon by ships. Why? Because those ships can go very far away. And we should still consider CO2, at least in my opinion, that these are wastes. So we should all be very aware that wastes produced in the north do not end up in the south,
Yes.
stored somewhere
Precisely.
else.
Yeah.
So,
Yeah.
so this question is something that to look further in the future. If the technology scales up, what will happen, and what is the
Yeah.
responsibility of those states accepting CO2? If
Yeah.
we look
Yeah.
back at the transboundary movement of wastes, the history is not very good.
Yeah, yeah, precisely. Plastics and all sorts of things like that, right?
Yeah.
Yeah. Okay, then Lily Booker, who is going to be an intern at the Marine Board as of next week, she says, after how many years are the liabilities transferred to the state?
At least 20 years.
Okay.
So it's not that much, actually.
20 years from the start of operation or from the end of the
20
operation?
years from yes, 20 years since you inject
Okay. Yeah.
the carbon. So, but there is an exception that if the operator can demonstrate that everything is extremely safe and contained, that for exceptionally the transfer could occur earlier.
Yeah. And I actually have what that dovetails with one of the questions I had. When you say it transfers to the state, it transfers to the member state, right? Not to the European Commission or European Union.
To the national authority.
Yes. So if it's in Belgian waters, then it transfers to the Belgian state, the
Exactly.
risk. Okay.
Yes.
Or the liabilities. And then she goes on to say, do you see a risk that private operators might take advantage of the EU CCS directive's liability handover model by ensuring storage sites appear non-leaking only during the years that they are responsible, potentially neglecting long-term risks or maintenance after liability transfers to the state?
Well,
Very good question.
I think this is a very good question, but I think a little bit on the technical side. We should know that both the authorities and the operators both should have technical people on board. So,
Yes, yeah.
so the state is not blind to all the reporter or data.
Mm-hmm.
If private operators are lying or being corrupt, then other mechanisms come in. As I mentioned, for instance, the EU Environmental Liability Directive. And we now have also, the EU has amended, and we have now the new EU Environmental Crime Directive. Does not criminalize CCS in particular, but could be relevant as well. So the questions directs of a matter of being being knowledgeable and hiding information. So then we enter into the realm of crime.
Yeah, yeah. Then Athol has a question, but I think that follows on from that. Considering that the operators need to monitor for decades to avoid the leakage, could there be any legal barriers to use that monitoring data for science, say for future marine CDR?
Yes. So this is, I think, in all the new technologies, how data is first collected, and then who has access is always a problem. So in principle, it should be available in order to harmonize how we are monitoring, reporting, and verifying that this works. So yes.
Yeah, but would that be not just between, say, companies doing the same thing, but between companies doing different things? Because he's talking here about the CCS and CDR, and these are two different things.
Exactly, but this is a real problem, the asymmetry of information that we have available.
Yeah. Then there's a question from Akrita Kaul, who asks, what do you think would be the interplay between CCS and the BB&J agreement, and its pillars of EIA and capacity building and technology transfer?
Well, okay, so the BB&J agreement deals with the protection of biological diversity in areas beyond national jurisdiction. At the moment, CCS is built under this logic that there should be one specific state that has the oversee of the activities. And there is, I don't think, any type of feasibility, at least until now, to sequester carbon in the deep sea bed. But that will bring another type of questions. Could we consider CCS as a freedom of the seas? Is it possible to sequester in areas beyond national jurisdiction? Who will be the responsible state? Maybe the flag state? But since we have now a whole treaty system, those should also oversee, because now the BB&J also establishes cooperation mechanisms between all these multiple organizations having certain type of competence in the high seas. But I don't see that. I don't know if there will be a moment in time that that the CCS can be actually be stored in the deep seabed.
Yeah, but I guess it's not necessarily that it happens in the deep sea, but that the impact would be on the deep sea. You know, if you have leakage and it goes into the areas beyond jurisdiction, then there must be an interplay. Then there must be an impact that would have. So, and who knows how that would play out. I think that would
Yes.
be interesting to see.
But that, of course, is always subject to the liabilities either of the operator or the state.
Yeah.
They must restore the affected areas. It is irrelevant if it is within national or outside national jurisdiction.
Yeah. Then we have a question from Matthias Kruisberg. He says, if he remembers correctly, there was a major legal reform, KSPTG, whatever that means, enacted, permitting commercial CCS, CCU, CO2 transport infrastructure, and offshore storage starting this year. How do you think Germany's regulatory offense force future adaptations? Yeah, how does Germany's regulation force the future adaptation of the EU CCS policy?
I have not looked into how Germany is regulating CCS, but I am aware that for many years they were against the CCS, but now they at least are open to sequester in continental shelves elsewhere. But I have not looked on what are the contents of their legislation. But their legislation has to be compatible with EU and international law.
Yeah. Okay, then there's another question from an anonymous attendee who says probably depositing CO2 and monitoring it will also need a continuous amount of seismic monitoring at least once a year or every 2 years. Can you give some insights into that? Who will pay for this? As I guess, especially, I imagine within the first 20 years that should be covered by the company, but post that, who will pay for this? What are the impacts on the environment through seismic monitoring? Because seismic monitoring has impacts. And what if there's a leak detected? Who is responsible?
There is, if I am not incorrect, the CCS directive also imposes a financial contribution for at least 30 years after the closure to co-finance this or finance the monitoring. But then it's the state. This is a regulatory choice. The state has chosen that they will take care of the monitoring. But there is always this assumption that the states are there permanently and forever and funded. There could be cases that states also could disappear, could be failing states, no money left. So yeah, it could happen. But
yeah, I mean,
least...
and if there's a political change in a country where the country had under one political regime said, okay, the state will pay for this, and then the next political regime says, oh, we're not going to pay for this, then what happens?
Well, then is of course you can of course change national legislation, but you will have to. There is the operators could go against the state, and if possible, there could be a state responsibility as well. But these things have happened in the past. That is the problem with CCS, that we are looking to responsibility of decades and even centuries, with the assumption that there will always be an authority there. This assumption is, I think, very illusory.
Okay, then there's a question from Estefania Cortez saying, thank you very much for the talk. Considering governance does not rest on single legal instrument as they need to be applied together, is there a specific priority of regulatory application in specific conflicts of use of resources, environmental concerns versus possibility of CCS environmental in vulnerable ecosystems such as the Baltic Sea? So is there which regulation comes first? I guess is what she's asking.
So from a legal perspective, we have several alternatives. And at international law, you usually find what we call conflict clauses that will give prevalence in terms of conflicts to a certain convention. If they are not available, we follow principles such as speciality. So we say, well, that the HELCOM Convention is special for the Baltic Sea, while the London Protocol could be considered of general nature. So the HELCOM Convention could prevail. But if we look at the logic, because all of these treaties function under the logic of the law of the sea. And the law of the sea mentions that in the exclusive economic zone, where most of these activities will take place, there is an obligation of due regard. What does it mean? Is that when we have all these states, let's imagine that HELCOM decides to allow CCS. Before you start, there is a balance of interest. If there is, Stephanie, I think, mentioned that there could be resources or another type of uses. Due regard means a win-win situation. Those states and those actors must balance to find a way to move forward. So it's not immediately that the coastal state will have preference or not. Then internally, one state, they could also, if they decide to do CCS in their own continental shelf, that could conflict with other users. And that is why, for instance, here in Europe, they have the maritime spatial planning with the specific obligations of consultation. So how to make these priorities at national level are governed also by national law. In many states, this could be not the case. It's the authority that decides the priority. But at least here in Europe, it's supposed to be that all the voices should be heard and count into the decision process to make these priorities. But at sea, there is no single user that has permanent right to conduct a certain activity.
Okay. And then Lily again, she asks, should operators be required to pre-fund liability trusts? And that actually is part, also kind of comes to a part of another question that Angel had. What would happen if the operator goes bankrupt during the operation of CCS? Who would take the liability? So during operation, what happens if they go bankrupt? Who's then liable? And then would it be useful for operators to be asked to pre-fund a trust that actually would look after it?
Yes, exactly. The CCS directive actually provides for this financial security before giving any type of license. So this financial security in terms of an insurance will operate in cases that the company goes bankrupt. In case of, I don't know if the question also referred to ship transportation.
Well, I think Lily's question was just on liability in general, and Angel was just what would happen if the operator go bankrupt. I mean, that's also true for the ship operators, I guess.
But with shipping is a little bit complicated because shipping is not included as a mode of transportation in CCS. So that's a major gap. So we have general limitations of liability in maritime law. And maybe the hazardous, there is a convention concerning the transport of hazardous substance that could be potentially applicable, but it's not enforced. What will happen with shipping now is that it will be regulated, at least for now, by private contracts. It's a common feature of shipping that you divide liabilities in contract law. So I know that BIMCO, that is one of the major players in the maritime industry, will draft a clause concerning the transport of CCS.
Okay. And then you're saying that the liability, this is happening at a private level for the legal side of things, right?
Yes, that is what we call civil liabilities. Yes.
Okay. Yeah. Okay. Then the another anonymous attendee said again, thank you very much, that to make it clear that CO2 is a waste. I think people forget that sometimes. And Isabel Taylor said, Thank you for a very informative webinar. I was wondering how subsea CO2 storage sites are monitored over the long term, and to what extent seismic surveys are used as part of the monitoring. I guess it's quite a technical.
Yes,
Yeah.
sadly, I have not an answer to that.
Yeah, I think Izzy, if you look into the literature, you'll probably find it quite a bit of information. I know there were quite a few EU projects on CCS that had quite a bit of information on that. But given that Gabriela is a legal expert, I think we won't ask her to answer that question. Then I think the final question is from Emil Ilsmaris. Thank you for the presentation. Have there been any reported leaks, unauthorized discharges, or environmental incidents to date related to CCS operations? And are there any court cases related to it?
No, you know that the development, the deployment is at commercial level is such incipient that it hasn't happened. I am not aware that there is any type of leakages. There is a report that I haven't read in detail concerning Snøhvit, that is a storage site in Norway, where the authors were claiming that there is no. I'm sorry. Hija, estoy en reunión, por favor. Sorry. So that there is that the carbon streams were not behaving as it's supposed to be. That was at least part of the abstract, but I am not aware that this is happening. And why? Because this is just beginning. So
yeah.
So more information to come.
Yes, and I also know that there were some EU-funded projects maybe 10 years ago now that actually looked at, what happens if you have these leaks. So they had looked at the biological and physical and chemical implications. So there's definitely the information out there. Then Anko had another question. Is induced seismicity included as part of civil or environmental liability?
Can you repeat, please, the question?
If you look in the chat, I think he wrote it there. Is induced seismicity included as part of civil or environmental liability? He gives
I am not sure about it. I think it will depend also on the license and the obligations under national law.
Yeah. All right. I think we can stop it there. It was very interesting. I had a few questions, but I think most of them were covered by the other people's questions. So that's great. Thank you so very much, Gabriela. This was really, really interesting. I think we covered all of the questions that people had in the Q&A as well. So thank you very much. I think we only have one thing left to say that our next webinar, I'm not even going to put my slide up because there's not much to say other than it will be in February, but we do not have a confirmed speaker yet. So there will be one, but please follow us in our newsletter to find out when. It will always be on the third Thursday, so that at least you know the time, but maybe not the speaker. So we will see you all next month again on the third Thursday of the month. And thank you again very much, Gabriela. It was a very, very interesting talk. And
thank you.
As much as we didn't talk too much about CDR, I think it was very relevant because it's also such a new thing. And I think legally, there's probably quite good similarities there. Yeah.
Yes.
All right.
Thank you and have a good week.
All right.
Bye-bye.
Thank you.